What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hope you guys are all having a great Saturday. Yeah. I was debating either doing a premiere or just going live, and then I was like, let's just do live. Let's just go live. You guys know I don't stream Saturday nights because I hang out with Heather, but yeah, do it during the day. Still gives us plenty of time at night. Anyways, got 3 clips for you. First one's just weird. Hopefully, you guys get a little chuckle out of it. I sure did. Second one is the Judge Washington clip, which is actually a follow-up to a clip I played a week or 2 ago. And then the last one is a sovereign citizen. Well, he's a sovereign citizen, but he's not full sovcit. How about that? All right. Is that all I was going to say? Oh, no, I wanted to thank, real quick, Jason, thank you so much for becoming a new member. I appreciate it, bud. I know you were having trouble figuring out the buttons yesterday because Apple devices are weird, but you got it. Thank you so much, man. Hope you're still here. Okay. Before I hit that play button, you know what to do. Hit the like and subscribe. Do the jump kick backflips. Let's go.
Proceed.
Very well. Good afternoon, everyone. My name is Lawrence Smith. I'm the chairperson of the hearing panel for the Tri-Valley number 3. It is approximately 1:47 p.m. on the 23rd of April, 2024.
Hi, could you come up here as soon as possible?
Mr. Kaprinsky, could you kindly remain silent while we begin the proceeding? This is a hearing of the Tri-Valley County Hearing Panel number 3 of the Attorney Discipline Board of Michigan in the matter of grievance administrator versus Edward M. Kaprinsky, P number 34114.
Okay, now hold this down with both fingers.
2-97-GA.
Okay.
The panel is comprised of myself, Lawrence William Smith Jr., chairperson Roseanne M. Junta, a member, and as well Nathan J. Collison, a member. Panel has been appointed by the Attorney Discipline Board, which is the adjudicative arm of the Michigan Supreme Court for the discharge of its constitutional responsibility to supervise and discipline Michigan attorneys. Counsel for the grievance administrators Pamela I. Linville, who will represent and present the case for the Attorney Grievance Commission, which is a separate branch of the Michigan Supreme Court for the investigation and prosecution of discipline matters. This hearing will be conducted in accordance with MCR, that is the Michigan Court Rules 9.115, the rules for circuit court bench trials, and the Michigan Rules of Evidence. In accordance with MCR 9.115J, the hearing panel has conducted a hearing to determine whether misconduct charged in the formal complaint has been established by a preponderance of the evidence. Panel, having concluded that misconduct has been established, will now conduct a separate hearing to determine the appropriate discipline. At this hearing, the panel will consider the evidence which is admitted for the purpose of showing mitigating or aggravating factors. The decision of this panel may be appealed to the Attorney Discipline Board, grievance administrator, the respondent, or the complainant. We'll now proceed with the hearing. So in advance of the hearing.
All right. In summary, the attorney in the top right kind of messed up. I don't know what he did, but he's in front of a disciplinary committee right now for his whatever his sanction is going to be. Another committee already found that he did violate some rule, and this is supposed to be his, I guess technically his sentencing maybe, but he can't figure out his tech. He doesn't know what's going on, which I don't know. It's a good way to get out of it, maybe. I don't know, but it's kind of funny just watching this guy on the top right where he's supposed to be in trouble and he's messing around with his tech the entire time.
I had received on April 19th, 2024, a motion to reopen the adjudication and postpone sanctions. I understand there has been a response to that motion by the prosecutor, although I do not have that. I think it's coming my way. Others may or may not have it. In response to that, there was a reply by respondent requesting an adjournment to a later date. I would note for the record that it is now 1:50 p.m., that this hearing was to originate at 1:00 p.m. Panel members and staff and the prosecutor were all present in advance well before 1:00. However, Mr. Kaprinski did not appear. He did not call. He has not responded except for upon being called by the Attorney Discipline Board staff. I would entertain comments from Ms. Linville. However, at this point, I believe that we are not in a position to go forward without dealing with the motions that are currently before the panel. Ms. Linville.
Thank you, Mr. Chairperson. Good afternoon to you all. Pamela Linville on behalf of the grievance administrator. This matter was set on February 28th after misconduct was found. And this panel also accepted Mr. Saprinski's no contest plea to some of the counts. The hearing continued, and then the panel adjourned and deliberated and found misconduct as to those counts that Mr. Saprinski had not pled no contest. On that date, February 28th, this panel decided to grant my request that we adjourn for a later sanction hearing and that we could conduct same on Zoom. Shortly thereafter, I believe calendar was circulated and this date was selected. So we've had this date for quite some time. I can say that yesterday afternoon, the grievance administrator received respondents' motion to reopen the adjudication record and to adjourn this sanction hearing. I don't know what date he filed it. I heard Mr. Chairperson indicate he received his copy on the 19th. I can indicate that I received my copy in the mail yesterday and began drafting a
That's I see it. It is Bert, the geologist. Love it. Love it.
response. My response objecting to Mr. Saprinski's motion was filed today between 11 a.m. and noon, and it is lengthy. I believe that his motion is untimely and on the merits that I address in my response should be denied. Shortly after the time of the sanction hearing was beginning to start at 1:00, I received 3 separate replies from Mr. Saprinski via email asking for an adjournment so he has time to review my response and perhaps file a reply. That's where we stand at this date and time.
Well, I believe that, speaking for my co-panelists, that we are inclined to grant an adjournment at this point in favor of a live hearing in light of all of the problems that we've had
please.
preparing for this
You
hearing
just stand, hold it.
and actually engaging in it.
I don't
Mr.
know.
Kaprinski is talking at this time and apparently
Well, then
not
open that
hearing
door.
communication
Here, let's turn this
from the
off.
panel.
Just grab the door and open it. Here, I'll hold this. Opens up all the way.
I could just go get a piece of Velcro and it would stay right where you need it.
I know, but I can't afford to have it.
Mr. Saprinski, will you please sit down, sir?
Velcro's right
You're
there.
interrupting our chairman.
Okay,
You're
go get it
interrupting
and I'll
this
hold
hearing.
this.
Sit down.
Okay? And then hold that door open.
Yes, Jedi. He's the one who's being disciplined. the guy who is, well, yeah, you can see.
At this time, unless there is some objection from Ms. Linville, I am inclined to grant
Put
the
that camera
motion
big
to adjourn the
and
matter
put it
for a
in place.
live hearing to be set in the future. Ms. Linville, would you reply, please?
Thank you. For this record, it doesn't appear that we have Mr. Saprinski's attention, although we can see him on the screen and hear him.
Yes.
I would ask that we reset this to an in-person sanction hearing because of the technical difficulties, and that
Here, I'll hold it.
I don't know if the panel needs to have oral argument on this motion separate from the sanction hearing, or if the panel would choose to do it all at one hearing. I would leave that to your discretion.
Thank you very much. I appreciate your courtesy and your patience in this matter. I believe we would be able to respond to the motion at the hearing, live hearing, and dispose of that issue. And if we are inclined to go forward with the hearing at that time, we would just do so. Unless there is other comment from my co-panelists, I would ask that this matter be adjourned, or I should say order that this matter be adjourned to be set for a live hearing, preferably in Midland, Michigan, at the place of the former hearing, at a time convenient for all parties.
Thank you.
It can be too much. It doesn't matter.
Do we need further on the record, further matters on the record? Anybody?
Not on behalf of the grievance administrator.
Co-panelists?
Done that.
Nothing further.
Mr. Kaprinski, are you familiar with what was just said and that we are adjourning this matter for an in-person hearing
I mean,
to
we
be
should
set
have
in the future?
stuck them together like that.
Mr. Kaprinski. Mr. Kaprinski, can you hear me? It does not appear that Mr. Kaprinski is able to hear the audio portion of my comments.
Wouldn't have to be fucking around.
And I trust that staff can call him and let him know the situation. All right. Ms. Grau, can you do that?
Yes.
Very good. At this time, I'm going to adjourn the hearing.
Sit down, I'll
Be
adjust
set in
it
the
for you.
future.
Thank
You
you.
can adjust it.
Thank you. I apologize to everyone for the time they have wasted today.
All right, yeah. So not only was he 45 minutes late to his own sanctions hearing, he didn't participate at all. Even if you couldn't get the audio to work, sit down, man. That was extremely rude, especially for an attorney. All right, next one is Judge Washington. It is like I said at the beginning, it's a follow-up to a clip that I played a few weeks ago. It was like 1 or 2 weeks ago. But the line that you might remember him by was he was asking to get his tether removed. And he's only been out of jail for about I think it was 2 weeks at that point. He's like, "Oh, remove my tether. I haven't done anything wrong." And judge is like, "No, you just got out of jail. You can go back to jail if you want." And he's like, "All right, well, anyways, all these charges are going to be dropped." And Miss McDuffie just kind of went off on him for saying that. This is his next hearing. All right, let's go.
Terrell Daniels.
Turn on your screen, sir. Oh, there you go. Thank you. All right, we're here for a pre-trial today.
Yes, Your Honor, I have went through the offer from the people, and Mr. Daniels wishes to reject that offer and set this for a final settlement conference. If Ms. McDuffie doesn't mind putting that offer on the record again.
Will do. Mr. Daniels had two options for an offer. One was to plead to count 2 on the complaint, which is domestic violence with 7694A. I'm sure that he understands what that is, which is the first offenders program that would have that case be non-public and then dismissed from his record entirely after probation. He would also be pleading.
If you're talking about the last case, it was in person, so I wouldn't have got it. So no follow-up to that. That was just, a fun way to start off the video.
To count 3, which is child abuse as charged. I'm not offering a deferred upfront on that, but I would consider it basically after the fact. So should he complete probation with no major issues, I will leave a note for the next person at that point, if it's not me, with my approval that could be dismissed at that time. The entire case would be non-public due to the 4A status on count 1 had he taken that offer anyway. The option 2 was to plead to count 2, which is domestic violence as charged without 4A, and then dismiss count 3, so that the maximum on that case would be 93 days instead of 1 year. As for sentencing, we had some requests, and one of those was alcohol treatment, so that would require an assessment I would have requested testing on this case due to the history, but it wasn't, so that is what it is. And a mental health evaluation as well. We actually had a request for some upfront jail to be served prior to probation, but due to the fact that Mr. Daniels, one, had been in custody for some time, I didn't formally include that in the agreement. Mr. Daniels, I think I just leave that up to the court based on what the court deems appropriate. The victim has asked that no contact, no go-to orders
Thanks, Bob.
remain in place as long as possible, regardless of rejection of the offer. I explained to Ms. White, we've had a series of defendants who have rejected offers, set their cases for trial, sometimes been convicted at trial, and then ask for their offers afterwards. I am going to stop with all the flexibility I've had. So Mr. Daniels needs to understand, rejecting that offer today means it is completely off the table. We are not going back. It is not being reopened. If he wanted to think about it, he needed to request an adjournment today instead of setting it for a final settlement or bench trial. So he knows that today is it, those offers go away.
Mr. Daniels, is that what you want to do, or do you want to break out room to discuss it further?
No, I'll take it to trial.
Final settlement conference in this case. Gonna be on July 25th. 2024 at 11 a.m.
Is it something I can say? Is it something I can say?
No.
Like, are they gonna like get you off the tether so you can get a job?
That's gonna be there.
I mean, if it's something I can say or like help, like, you know. Like, you don't want to be defeated. Like, it's not defeated. You know?
I feel defeated though.
Well, no. Like, what if it's too late? Like, I waited too long and now my body is super like some sort of done. I mean, eggs.
I have not figured out the grilled cheese pizza yet. I haven't figured it out. I will though. I will. I did think about it a couple different ways last night, but none of them are good. None of them are really that good of an idea yet. But don't worry, it will come.
Is it something eggs?
All right, and jury selection is going to be on August 9th, 2024 at 8:30 a.m.
May I address bond?
We did that last time we were here.
Yes, we wanted to know if Your Honor would consider a GPS tether so that Mr. Daniels currently doesn't have a phone, and he was trying to apply for employment, as Your Honor knows, but it's a little hard. He has to borrow a phone, so he would like to get out, look for employment, hopefully get some money to buy a phone and take care of some other matters.
Ms. McDuffie?
Your Honor, we did address this at the last hearing where the home confinement tether was the alternative to incarceration, I think awaiting trial. In terms of not having a phone, I don't really have any comments on that, or as to whether home confinement versus a GPS tracking tether. The victim just doesn't want any contact. I'll leave it up to the court, but I do recall that Mr. Daniels made the comment regarding his tether that's okay, the case is going to be dismissed anyway. So he seemed to be okay with having it on due to that belief last time. So I'll leave it up to the court.
What I don't understand is why he is unable to look for a job when it says in here that he can go look for a job with the home confinement tether. I don't understand, Ms. White.
I did discuss that with Mr. Daniels. That apparently there's other things that he needs to take care of. Where he is currently, he is not contributing to the household. So he would like to be able to get out and help with the groceries and other matters.
I don't know if that answers my question. He could help with the groceries. Are you talking about grocery shopping?
Yes.
Okay.
If I could get an opportunity to speak, please.
You did that last time, sir, but go ahead. if your attorney is okay with that.
Is it possible while I'm talking to you, if my sister can be on camera with me, please, who I stay with?
No, your sister can't speak for you, sir. We can hear her clearly in the background. I'm glad you explained who it was.
Is it okay if I speak?
I just said no, ma'am. It is not.
Okay.
Your Honor, I have no reason. I have no reason to contact this lady. I've been falsely accused of
Mr.
crime.
Daniels, we don't want to talk about that.
Okay, all right, I apologize. I'm just trying to put myself. I've been locked up since December of last year. Then to be locked up, to come home to be on house arrest. I'm not accomplishing anything. I have no ill will or have no intent of doing anything to this young lady or whatever. It's just mind-boggling to me because we was just together and all this. And all
Mr.
this
Daniels, well, Mr. Daniels is saying he has no desire to contact anyone, and
I heard him. I heard him this way.
okay.
Ms. McDuffie, did you say that you don't have a position on whether or not it is home confinement versus GPS?
Your Honor, no. I think the reason that he was remanded, if I'm not mistaken, was because of calls to the victim while he was in jail. I actually haven't listened to those yet, so I don't know what the context was, what the substance of that contact was, but that's I think how we ended up here, what was contact. So I think the same effect is going to be reached if it's a hot zone versus home confinement.
And do you have the address for me to do the hot zone?
Yes, one moment, Your Honor.
And is it one that can be shared online? Like, is he aware of it? I don't want to give out her address if he's not aware of it. So I don't,
Right.
I would know the answer.
Hey, Pat's Cat, good to see you. And thank you so much for the 6 months. You are one of the few that have hit that milestone. So thank you so much. I appreciate it. Hey, Kathy, good to see you.
To that.
Yes, ma'am. I am aware of her address in Ypsilanti.
Okay.
If the court has, do you have the apartment 52 address? I don't know if that's any complaint or not.
1 second.
Okay.
Yes.
Okay, it will be that one.
Okay.
People who love her family testifying for history of tomorrow. Each of you will act as prosecutors for each of the cases. Their moment in the sun.
So you're staying in
I don't know. I was fine with it.
Inkster, where are you staying at right now, sir?
I'm staying with my sister right now in her basement.
Sir, what city is that in?
It's in Inkster, Wayne County.
All right, thank you.
On fire, partying it up, back in Ondo Chica.
So you say you know her address. You are not to go to that address or be within 5 miles of it. Okay.
Yes, ma'am.
You want to join this 9
So I'm going to allow it to be switched from a home confinement to a GPS tether. You need to go to community corrections after what time today would you think? Okay, you can go there after 1:30 today, okay? And they'll switch you over to a GPS tether. You cannot be within a 5 mile radius of her address, no contact with her whatsoever. That continues, okay?
Yes, ma'am.
All right, you're all set, sir.
All right.
Yeah, see what happens when you don't yell at the judge and the prosecutor and listen to your attorney. You know, chances are you might get what you want. And he did. All right, last one. This is the sovereign citizen, Judge Gauthier. Yeah. It's about a week old now. So I know it's been out there. It's been floating around on other couple channels, but you know, I wanted to play it, and it's Saturday. Court's slow, so let's go.
We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. First this morning, we've got People of the State of Michigan versus Trevor McLeod, file 23-6748FH. Counsel for the people, you want to state your appearance, please?
Anthony Julie on behalf of the people.
All right, and Mr. McLeod, good morning, sir.
Morning.
Again, every time we come into court, I'm going to be required by the court rules to confirm that you wish to represent yourself in this matter without the assistance of an attorney.
That's correct.
All right. We're here for a docket call as well as several motions that you filed up, that you noticed up. One of them does require some testimony. That was the motion to suppress the chemical test results. Your filing the motion triggers the prosecutor's burden to establish that that search was taken properly. Is there any opening statement you want to make, Mr. McLeod, about your motion to suppress the chemical test results? And you'll have an opportunity to argue after the testimony as well. Any opening statement you want to make?
Well, I just received an email from Julie Rattel. I don't know if she's a court administrator or clerk.
She works in the prosecutor's office.
Okay, I just received an email from her on Friday with the warrant that was never found in Discovery or anywhere. It just turned up Friday magically, I guess.
Okay.
So I'd like to open with that.
Okay, Mr. Juliet, any opening statement?
No.
All right, and your witness?
Conservation Officer Burgoyce.
All right, Officer Burgoyce, would you please raise your right hand for me, sir?
Yes, it is. I like that name you gave to him, but yes.
You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Go ahead, Mr. Juliet.
Sir, can you state your full name and spell your last name for the record? Alexander Bourgeois, Bourgeois. Thank you. And where do you work? I work for the Michigan DNR. How long have you worked there? I got hired in July. I've been working the field since August of 2022. So 2022. Okay. Were you working on September 4th of 2023? Yes, sir. Okay. And did you have some interaction with the defendant, Trevor McLeod, that day? Yes, sir. Is he present in the courtroom, if you can see? I can't see, but I saw him earlier. He's in the defendant seat. Yeah, can I let the record reflect that? September 3rd. Can I let the record reflect the officers identified the defendant?
Yes.
Thank you. Can you describe what caused you to have contact with him? Initially on that day, we were doing a BOI patrol, and other COs notified me and the other officers that were in my patrol boat that there was a boat with expired registration. We went to the Forks boat launch to make contact with that vessel, and subsequently we found out that the defendant was intoxicated while he was operating the vessel, and that led to the arrest of him. How did you find out he was operating while intoxicated? Once he had exited the vessel, I noticed that he had to use the post on the dock for his balance to get out of it. He took off his sandals, then walked to the bathroom, and as he was walking, he stumbled and swayed back and forth along the dock and up the ramp of the boat ramp to the bathroom. And then the same thing coming back. Myself and other officers observed this, and that's when we made contact with him. Okay. When you made contact with him, were there any other signs of intoxication that you could tell? Yes, while talking to him, I observed slurred speech. When I asked him for his documents, for his boat and his driver's license, he lacked fine motor skills. I couldn't pick through the papers. That's a common sign of intoxication. And then when he was stepping into the vessel to go get the registration for the vessel, I noticed that it took him about 10 seconds just to put on one of his sandals. That would show that he was lacking fine motor skills, couldn't put his foot inside of the sandal to put it on. Did you perform any standardized field sobriety tests? No, sir. The defendant refused. Okay. So what happened after he refused the field sobriety test? Myself and Officer Listenfeltz, we advised him that he was going to be under arrest for BUI and asked him to exit the vessel that he was in. He refused, even though we gave him a lawful order. We told him that if he didn't exit the vessel, that additional charges would be brought against him, resist and obstruct. He still refused to. Officer Listenfeltz got inside of the vessel with him. We told him to place his hands behind his back, that he was under arrest. And Officer Listenfeltz went to grab his arms, put his hands behind his back. The defendant pulled away from Officer Listenfeltz. And during this time, a scuffle erupted and Officer Listenfeltz fell on top of the defendant. He put his arms in front of him so that way he couldn't be cuffed. During this tussle, Officer Listenfeltz was able to pull his left arm behind his back and put a cuff on it. And then the defendant still kept his right arm on his chest. At this time, I pulled out my taser. I took the cartridge off so that I could use the dry stun option. I had to tell him 4 times that if he didn't comply, he was going to get tased. And then finally, Officer Listenfeltz was able to pull his right arm behind his back and handcuff him. Okay. So it's
It helps when I unmute. Hey, Dwight, thank you so much. I appreciate it. Thank you so much for the super chat. Yeah, I usually buy my intoxicants in vessels too. I like it. I like it. Thank you, bud.
At some point, did you arrest him for voting under the influence? Yes, sir. And is there a procedure within the Department of Natural Resources for what to do when you arrest somebody for voting under the influence? Do you draw blood or do you use a data master or anything like that? Yes, sir. It's the same as if it was a motor vehicle. Obviously, with how he acted, we knew that he was going to refuse. So once we got to the jail, the Sheboygan County Jail, Officer Listenfeltz read him his DI 177, which I think it might be called something else for DUI, but his chemical test rights. And then I started typing up the search warrant because we knew that he was just going to refuse. And then we went and got the search warrant for his blood. Okay. Do you know if he actually refused or? Yes, sir. Okay. And you said you were the one that typed the search warrant? Yes, sir. Okay. Do you have a copy of the search warrant with you? I have it about 10 feet away from me if you'd like me to grab it. Can he grab his search warrant? I just want to authenticate it for an exhibit.
Sure, Officer Bourgeois, if you want to go retrieve that.
Okay.
I object to it as exhibit. This just
Well,
turned up on Friday.
Okay, well, it hasn't been offered just yet, but you're about to offer, right?
Yes.
All right, so the objection is that it was not provided during discovery.
3 different requests for discovery.
In
Well,
response to that.
I don't know. I mean, it's his motion to suppress the search warrant. I mean, I think I should be able to offer it as evidence.
Right, well, I mean, do you have any response to the discovery objection that it wasn't provided or?
I do. We didn't have the search warrant in our file. We had to call up to the jail last week and get it. So when we got it, that's when we emailed it to them.
Okay, that objection, Mr. McLeod, will be overruled. It's far in advance of trial. We haven't even set a trial date. We might end up doing that this morning yet, but we don't have a trial date.
So if we're allowed to keep bringing discovery, I'd like to allow my witnesses that I forgot to call for their discovery to be brought into the case also.
For what? For what purpose?
For the trial.
The trial, yes, we haven't even, so if I set a trial date today, there'll be a deadline to file witness and exhibit lists. Okay, you'll be able to do that. Yeah, discovery's just got to be done well in advance of trial. And for purposes of responding to your motion today, then it's appropriate. All right, go ahead.
Officer, do you can you recognize who's the magistrate or the judge that signed the search warrant? The signature is in cursive, but it looks like the first name is Mariah and then Ellen Bowe. It's hard to read the last few letters of her signature, but it was a female that came in. Okay. And what date was that search warrant issued? 9/3. of 2023.
If I can approach for people's proposed one.
All right, you want to show it to the defendant?
Take a copy. I don't get one sent.
Is that the same thing that you got on email or?
Yeah.
Okay. Okay. For admission of people's one. All right, any objection to the admission of people's
Yeah,
exhibit one?
it's invalid. It doesn't have any details. It doesn't have a charge. The affidavit that's supposed to go with it is signed by the judge or by the officer. And it's completely procedurally incorrect. I wasn't provided a copy or shown that warrant at the time of the arrest. I haven't had a copy in the 3 request for discovery.
Okay, those objections are overruled. People's exhibit one is admitted.
May I continue, Your Honor?
Yes.
Officer, did you serve the search warrant on the defendant?
Yes, sir.
And where was that at?
It was at the Sheboygan County Jail.
Okay. And did you subsequently observe blood being drawn?
Yes, sir. Both myself and Officer Listenfels were in the room.
Thank you. I have another question.
Any questions for this officer?
Yeah.
Fine.
So on the day that you were out on saturation patrol, could you explain what saturation patrol is?
So, yeah, yes, sir. So, what we're looking for is it was a busy time of the year. You know, it's boating season. So, what we'll do is we'll put a lot of officers out, whether it's on the water or on land that would be used for transportation if an arrest is made. But we look for BOI, anything to do for with alcohol violations. So if we came across someone that was under the influence of boating, typically we either have officers that would take them to the jail for us, or that could go and patrol our area once we did that. But it's a large number of officers in the area specifically looking for BOI and safety issues with the boating season.
And all these officers have a pretty good training on the laws of OWI and have training on how to perform and execute these arrests.
Yes, sir.
Okay, so are you aware that according to the Natural Resources Environmental Protection Act, section 324-80176, subsection 3, that in order to approach anyone or board their vessels, if you suspect an OWI, the suspect has to be visibly impaired while underway?
Sir, you were underway. I think we covered this in the first motion you filed.
You never noted that I was visibly impaired while I was underway. In fact, you said that you did observe me through binoculars to see if my registration was expired. Is that correct?
Yes, I did use binoculars to see you underway with the vessel and that your expiration was expired. Yes.
Okay, the reason why you approached me was the expired registration. Is that correct?
Well, we docked next to you to talk to you about the registration, but once we docked next to you, then we observed the signs of impairment, which even if you didn't have expired registration, I still would have made contact with you because of the reasonable suspicion of intoxication.
And when you report, you state the reason you and your partner approached me and my family was due to an out-of-date registration. Is that correct?
That was one of the reasons, yes, sir. But again, we would have made contact with you regardless of the registration because of the stumbling and swaying up the ramp.
Is it common protocol to run a boat's license number on vessels that have an expired registration?
I can if I want to double check that it is actually expired, which typically I would do that if you could provide some type of registration that would prove that it wasn't. That's when that would run the number through lien to see if it actually was expired. And that if it wasn't expired, then we'd go through other avenues such as failing to display the new decal.
Okay, so would you admit that you're trained to notice out-of-date registration stickers on boats and off-road vehicles?
Yes, sir.
Okay. Is it safe to say that you likely noticed my out-of-date registration when we were actually launching our boat right next to you?
Well, we noticed your registration. Well, the other officers did, notified us of it, and then we went to the scene, observed that you were the driver that they stated was driving, that you were the vessel that that had the expired registration, everything matched, that we had the correct vessel that was pointed out by other officers. And that's when we docked next to you. So
No,
yes,
we
I mean,
launched, so that day, Mr. Bourgeois, that day I launched my boat right next to you guys launching into the water around 2 o'clock. Is that correct?
not that I'm aware of.
Okay, so when I was swimming with my family out in the lake and you guys rolled by us very slowly with no other boats around and waved at us, you didn't notice my registration then?
Well, so there was probably 10-ish officers. It probably wasn't me because I don't recall. And if that was you, sir, obviously we would have.
Yeah, that's fine. You answered my question.
Okay.
Is there a safety measure in place for officers to be sure that they're not encountering Native Americans on the water as they do not need registration? How do you approach that situation?
Well, sir, we treat everybody as if they're state fishermen or recreation. Once we make contact with the individual and they advise us that they are tribal, depending on what treaty they're in your case, the Sioux tribe and the 1836 treaty, we do have the jurisdiction to still check that you have everything that you're required by your tribe and continue a check. And if you don't have the stuff that you need, so say you're spearing, you have to have special permits that the tribe notifies.
Did you search my vessel that day to check and see if I had the required stuff?
No, sir, because you weren't in the act of fishing. You were driving the boat just down up the river.
So you didn't search my boat to see if there was any equipment that could indicate that I was fishing?
No, sir, because it's not applicable to the violation.
You didn't search. So you didn't search my boat, is that correct?
No, sir.
Okay. Do you have any evidence that at the time I was operating the vessel that my BAC was over the legal limit?
I had probable cause to believe that you were intoxicated upon the arrest.
That's not what I asked. Do you have any evidence?
Well, Mr. McLeod, that's not even relevant to the question here today.
Well, this whole thing is irrelevant. I mean, it's all based on hearsay and what these lying cops are talking about.
Well, this is a motion about whether the results of the blood test are admissible. So if you can direct your questions toward that question.
You say you obtained a warrant to draw my blood. That's correct?
Yes, sir.
Why wasn't I shown or given a copy of the warrant upon release?
Myself and Officer Listenfelds actually left copies with the jail, as the prosecutor stated earlier. That's why they weren't sent by me to the prosecutor. I have the affidavit and the search warrant right next to me. I believe they made copies, or at least we left the return and tabulation, which you're required to by law. So that was left for you at the jail by us, and Officer Listenfelds could testify this as well. But everything, all legal processes were covered by us at the jail.
Is it common procedure to not sign an affidavit?
I'm sorry, what do you mean by that? All my affidavits are all signed.
I'd like to submit exhibits from my motion to suppress. Exhibit 4.
That's the warrant.
It's well, I didn't have a copy of the warrant. It's just unsigned documents that are supposed to be accompanying the warrant.
So exhibit 4 to your motion was it says warrant felony. And then it's got the signature page with no signature and the return that's not filled out.
Yeah, and actually exhibit 3, also the affidavit of probable cause, which is unsigned.
Okay, the affidavit of probable cause exhibit 3. All right, and that's the 2 pages. Any objection to the admissions of those pages? We'll mark it as defendants A. No objection. All right, complete the list and mark it as defendants A. All right, that'll be admitted. I'm sorry. Sorry, it also includes. Okay.
Okay.
Yeah. All right, so those documents are admitted into evidence, Mr. McLeod. Question. Can you redirect?
No.
All right, thank you, Officer Bourgeois.
Thank you.
Further testimony needed from him today?
No.
Okay. All right, argument on the motion to suppress the chemical test results, Mr. McLeod?
Well, I've already shown that the warrant's invalid. It's got unsigned documents that are supposed to be accompanying it. So I would say that it should be upheld, that this warrant was invalid. It was executed improperly. It was not served on me. It was not given to me by release. It was not found in discovery with 3 requests. So it's very convenient that it turned up Friday.
All right, thank you, Mr. Juliet.
Just briefly, just based on, I understand the court has to make a credibility assessment here on whether the officer did in fact type up a search warrant and serve it on the defendant. He certainly had probable cause to draw blood. That's common procedure when somebody refuses a chemical test. The defendant displayed signs of intoxication, which led to the arrest for voting under the influence. He refused a chemical test. When offered one, based on the observations of the officer, he had probable cause to submit for a search warrant for blood. He did that. He typed out the affidavit, and it looks like, to me, it looks like it's electronically signed on defendant's exhibit 3.
Hey, welcome, Skyla. I hope I pronounced that name right, Skyla. Hope so. But welcome. It's good to see you.
He said that he served it on the defendant, left it in jail. So I would ask the court to deny the defendant's motion.
All right, well, the motion was to suppress the results of the blood test for alcohol in Mr. McLeod's body because the blood was drawn without a warrant. Based upon the officer's testimony in People's Exhibit 1, that blood was in fact taken pursuant to a search warrant issued by a magistrate. So therefore it didn't violate the 4th Amendment. The complaint and affidavit and warrant that the defendant's referring to are the charging documents for the issuance of the charge. That doesn't have anything to do with the drawing of the blood. There was a warrant for the drawing of the blood, and it was drawn. And the officers testified that they did leave the warrant and tabulation and affidavit at the jail for him. Whether that got to him or not is frankly immaterial. Even if it didn't, that doesn't invalidate the action of drawing the blood. That would violate the 4th Amendment if it was done without a warrant, but it was done with a warrant. So that motion is denied. Mr. McLeod, you also have a motion to dismiss on procedural grounds for a probable cause conference not being timely held or validly waived. Any additional argument you want to make on that motion?
Yeah, the waiver was supposed to be signed by both parties. That's state law, and only the prosecuting attorney signed it. And then neither my defense attorneys or myself signed it. I'm just curious how that transpired.
Hey, Mr. Juliet.
Just briefly, I did some.
Neither of his defense attorneys signed it? Where's your defense attorney? When did he have an attorney? I think this is the 3rd time we've seen him. He never had one, did he? Maybe in his first hearing he had one assigned to him. I don't know. I don't think he did.
A response to this, and I did research the case law on this. I did confer with district court. It doesn't look like a probable cause conference was held, but I did read the case cited by the defendant in his motion that dealt with the failure to hold a preliminary examination within the statutory time period.
Yeah, Kimmy, it's been years since I've been on a boat. but I'd be more terrified drinking on a boat and sailing it, I guess. I was going to say driving, than in a car. I really would.
That doesn't warrant dismissing the case. If anything, that would call for a remand, perhaps to district court.
Remand back to district court.
But in this case, and in the case that I cited, there has to be some showing of prejudice by not holding the preliminary exam or probable cause conference by analogy. In this case, there was a preliminary exam that was held and it was bound over by Judge Visnot. So I don't think there can be any prejudice by failing to hold a probable cause conference.
All right, yeah, Mr. McLeod, the purpose of the probable cause conference is to see whether somebody wants to run the prelim or waive the prelim to address any bond issues. You were already free. You weren't being held in jail, and you did run the prelim. So there's, even if a probable cause conference wasn't held, there's no
probable cause
prejudice.
conference could have stopped a lot of those procedures because the probable cause is all hearsay.
No, but see, probable cause conference, the prosecutor doesn't have to prove probable cause at that hearing. They have to prove it at the prelim. The probable cause conference, it's maybe not a great name for it, but that conference is just to address, are we running a prelim? What issues might there be at the prelim? Should the defendant be released from the jail pending the prelim?
But does it not still need to be waived by both parties?
It does, but the fact that it didn't has no prejudice to you. So defendant moves to dismiss the case on the ground the probable cause conference was not timely held and that it was not validly waived.
Actually,
I'm making my ruling now, Mr. McLeod. Defendant relies on People v. Weston involving the failure to timely hold a preliminary examination for an in-custody defendant. His reliance is misplaced, however. In People v. Crawford, the Michigan Supreme Court held that the Weston remedy must be invoked prior to the preliminary examination being held. In any event, Weston did not address probable cause conference, which did not exist at the time. The probable cause conference is to address possible plea negotiations, bond matters, and the scheduling of the preliminary examination. Defendant has shown no prejudice, even if a probable cause conference was never held and not validly waived. Moreover, defendant exercised his right to the preliminary examination. Dismissal is an extreme remedy, and defendant has not shown that it is warranted. Accordingly, his motion to dismiss is denied.
You say exercise my right to preliminary. Wasn't that kind of a forced situation under duress and threat of arrest?
It's your right to have a prelim, and you exercised it. So you exercised a right and it was held. So there's no harm to you. You exercised a right. All right, now you filed a second motion to suppress based on lack of sufficient basis for law enforcement officer to make contact. I'm not entertaining oral argument on that motion. It's just a repeat motion. Defendant moves to suppress evidence and dismiss the case based on a lack of sufficient basis for the law enforcement officer to make contact with him and a lack of evidence of his intoxication or impairment. This motion essentially raises issues that were argued in defendant's first motion to suppress. As explained previously, the officer had legitimate grounds to approach defendant based upon his observation of defendant operating a marine vessel with expired registration. Upon initial contact, the officer detected signs of impairment. Therefore, both his initial contact and his investigation were entirely lawful. Accordingly, defendant's second motion to suppress is denied. Mr. McLeod, you also filed a motion to reconsider the reconsideration. That's not really authorized in the court rules. I'm not entertaining oral argument on that. Defendant moves for reconsideration of this court's recent order denying his motion to reconsider this court's denial of his motion to suppress evidence for an allegedly illegal police contact. As the moving party, defendant bears the burden of demonstrating a palpable error by which the court and the parties have been misled, and that a different disposition must result from correction of the error. Moreover, a motion for reconsideration which merely presents the same issues ruled on by the court, either expressly or by reasonable implication, will not be granted. Defendant essentially raises the same issues that have already been briefed and argued. Defendant has failed to meet its burden of demonstrating a palpable error. Accordingly, the motion for reconsideration is denied.
I think you're failing to notice or recognize the lack of jurisdiction that you have in this.
Well, that brings us to you filed three more things, and I want to address those today because today was the motion cutoff. So you've got a motion.
And I don't consent to that anymore.
Hey, Nadavni, good to see you, buddy. And thank you so much for the super chat. I appreciate it.
Either I need more time to file these motions.
Nope. No, today's the motion cutoff. You filed 3 more. I'm going to hear them today. You have a motion to dismiss for lack of jurisdiction. We've addressed the jurisdiction previously.
You don't have jurisdiction.
I already ruled that I did.
You
This
can't rule that you
motion,
have your own
this
jurisdiction.
motion is denied. This court does indeed have subject matter jurisdiction over the charges by law.
Personal or subject
and
matter
personal.
jurisdiction. I object.
Your objection is noted and your motion is denied. All right, you filed a motion for disclosure of.
I love that. Your objection is noted and your motion is denied. I don't know why. When a judge says that to a sovereign citizen, it gives me goosebumps.
I don't even understand what you're talking about.
I don't know. Somebody else handled that.
What's that?
I don't understand.
You don't understand either? Okay. And that motion is denied. It's legally nonsense.
So all this.
And Mr. McLeod, you're filing, I mean, I'm letting you represent yourself and you're filing motions that you're telling me today you don't even understand. That's not a very responsible way to proceed. There's also a motion to recognize your subrogation rights. I have no idea what you're talking about. Do you? Can you explain it to me?
It's not necessary.
That motion is denied. It again is legal nonsense. All right, the time for motions has come and gone.
I don't consent to that.
Well, you don't have to consent to that. I gave you a motion cutoff. All the motions have been denied. Now is the time, Mr. McLeod, where you have the constitutional right for a jury trial. So I can set this trial for, would 2 days suffice, Mr. Julia?
I think we could probably do it in 1 day.
All right, well, just to be safe, we'll schedule it for 2 days then.
Yeah, Cloud, I'm gonna need 2 shrubberies. 2, not just 1, 2. Shrubbery.
I can schedule this for a jury trial, Mr. McLeod, on Thursday, Friday, August 8th and 9th. And what we'll do is we'll be here Thursday, August 8th to select the jury. And then we'll go immediately into the trial. As needed, we can, we'll continue into Friday. I'll have you both file witness and exhibit lists.
Does somebody that I know a lot of you said that you live close to the water and you're boaters. Are boat DUIs or BUIs is the punishment about the same as a DUI? Or I mean I don't know. I just feel like a lot more people drink on a boat than in a car. So just wondering. Legal nonsense. Boom. Yeah, that was good. Not indeed. Thanks again for the super chat. I appreciate it. And yeah, it's good to see you, buddy.
Within 21 days of today's date. Also, I'm going to have you file any side that wants to. I mean, the people have to. If you want to, you can as well. Proposed jury instructions by 21 days from today.
I motion to stay the court while I leave to bring this into the Western District Federal Court where it's supposed to be held. There's questions that you're answering and having opinions on that you don't have the jurisdiction to have answers. I brought that up in several motions and keep claiming that you do. It's clearly written in the consent decree that you don't.
It's manifestly untrue, Mr. McLeod. I mean, the consent decree doesn't mean that you can drive around on a boat drunk. And if the police catch you doing that, that comes in state court. It doesn't come in federal court.
Aren't you supposed to be an unbiased participant?
I am unbiased. You may not have been drunk. That will be for the jury to decide. I'm just saying I have jurisdiction over that allegation. It's not a federal.
You're interpreting the fact that you're trying to say that I was supposed to notify him that I'm Native American, and that's not true. And that's your interpretation. You're having an opinion.
All right, that's fine. And if I'm wrong, another court can tell me that I'm wrong.
I should stay the court so I can take this to the proper court for an opinion on what you're trying to have an opinion on that you're not allowed to have.
Denied. You can go to that court, and if they stay it, they'll stay.
Okay.
So what we're going to do is we're going to have within 21 days of today.
Oh, I just realized that there's less than a minute left of this video. Just paying attention to chat. All right, I'm going to let this play out. You guys all have a great rest of your Saturday. Enjoy your evening. Hold on. What is Night of Knee saying? Sovcits are empty hidden animal food. Yeah. True. And once again, thank you again, Night of Knee. I appreciate it. Okay. Enjoy the rest of your Saturday. This is it for me for the rest of the day. I will see you all tomorrow. And yeah, that's about all I got. So until next time, bye.
Both sides will file jury instructions and witness lists and exhibit lists for trial. We're going to come back for a docket call on May 28th at 9:30 in the morning in person here in the courtroom. And jury trial is scheduled for August 8th and 9th. Anything else today, Mr. McLeod? That's fine. Well, you don't, I mean, I'm giving you your jury trial, right? So you can have a jury trial. The jury's going to decide if you're guilty.
Trial by jury is what I require.
What's that?
Trial by jury, correct?
Yes, it's trial by jury. Yeah. All right. Anything further, Mr. Juliet?
No, thank you.
All right. Have a good day.